professional here, high tech. So, since 1998, Jory and I have a hard time with your last name,
Ruggiero.
Ruggiero. um, his practice has emphasized environmental protection, insurance, bad faith, and personal injury litigation. He was formerly a partner with the Bozeman law firm of Beck, Anston, and Ruggiero. And he formed Western Justice Associates in 2008. He served as president of the Montana Trial Lawyers Association, sits on the National Board of Directors, American Association of Justice, and he's listed as best lawyers in America. We have another presence here. Jory has also served on the board of directors of several other associations. That's where I condensed it all, because there are lots of other things that he's done. So I thought this was interesting. So prior to studying law, Jory worked as a biologist for the U.S. Forest Service, as a backcountry ranger for the National Park Service, and as an ethnographer in Northwest Alaska. And Jory chose to make Bozeman his home for the skiing, backpacking, boating, fly fishing, and other wilderness recreation opportunities. So glad to have you in Bozeman.
Awesome. Thanks, Kathleen.
Thank you.
Well, I'm psyched we have such a cozy little group today. This will be more than a formal presentation. It'll just be a conversation. So feel free to jump up and down and just ask questions anytime, and we'll just talk. Also, I saw somebody had posted something inviting providers. We have half providers here, basically. So the truth of the matter is the stuff I'm going to talk about, it's kind of wonky, esoteric insurance law and some medicine stuff, but a lot of fine print stuff that we could spend 5 hours talking about the shifting landscape for providers and billing in Montana for especially with liability insurance and things like that with acute injuries. And so if we want to have those conversations, I'm happy to have that talk too. Also, I just want to say thanks for the Concussion Resource Center. Those of you who don't actually work there or work for neuro rehab, it sounds like everybody in this room also knows how important CRC is. I guess maybe this is your first time, but CRC does all kinds of really lovely things for our community throughout the state and probably westwide. So awesome resource, really important. As Kathy said, I'm a lawyer here in Bozeman, and I'll tell you a little bit about the work I do so that you understand kind of my perspective on head injury and some of the insurance issues that I'd like to chat with you about. I've practiced law in Montana now for longer than I care to admit, and my law firm is called Western Justice Associates, I think, as Kathy mentioned. And I exclusively represent people against big companies, oftentimes insurance companies. My firm handles cases throughout Montana and mostly around the American West. And some of my work involves large-scale class action litigation. I'll tell you just a little bit about a couple cases that are kind of illustrative for where my perspective comes from, and also pertinent to the topics we're talking about today. So amongst other things, we just got through resolving 2 cases that I have worked on for probably about the last 8 years against Pacific Source Health Insurance Company and Montana Health Co-op, now Mountain Health Co-op, where what was going on with those companies was they're health insurers, and they made the usual promises that health insurers make. They say, we'll be your health insurance company. If you get hurt, we'll pay for your medical bills, whatever they are. And then what was happening is, starting about 8 years ago, well, longer than that now, 8 years ago when we filed the case, 7 years ago, was Pacific Source and Mountain Health Co-op were, if you were in an auto accident and you said, hey, I just got a catastrophic auto accident, I have a horrible brain injury or broken back or whatever it is, and you went to Pacific Source and you said, hey, you're my health insurance company, I've got $100,000 in medical bills, will you pay them? Pacific Source and Mountain Health Co-op were saying, oh yeah, we're your health insurer, but this is an auto accident. You need to go to the auto insurance. They're the ones who are supposed to pay for this, which is blatantly illegal in Montana. It still is. It was then. So we sued them and forced them to pay back. We represented 130,000 people just against Pacific Source, and forced them to pay back a lot of money to people that they had systematically cheated over the course of the last 8 years before we filed that lawsuit. So that's one of the issues I want to talk about, is the obligation of health insurance to pay in the context of situations where there's other kinds of insurance. But also it's illustrative of kind of the work that we do and where my biases come from. And those biases are, I live in a world where I see insurers just constantly trying to save money and not pay claims so that they have a larger bottom line and they don't have to pay money either to providers or to people who get hurt. And we see those cases because I represent hundreds of people every year that are in car accidents or have other acute injuries from, that involve premises liability or something like that. Like if you're walking through Home Depot and a giant bale of wire falls down and breaks your back or gives you a head injury, those kinds of cases. And when insurance companies try to cheat those people, we notice because that's our job. And that's how cases like those class actions I was just talking about are born, because we're like, hey, wait a minute, you're doing this to so-and-so. Who else are you doing this to? Because this looks systematic to us. And they're always like, oh, no, this was a one-off. Just a mistake. We never did this. And we get in discovery and we find out they sent 50,000 letters with the same misrepresentations in them. And so that's how we learn about these issues and why we're half smart about insurance law in Montana, although it's a dynamic landscape. So one of the most important roles that we play when somebody comes in and says, hey, I was just in a horrible car accident or some premises liability situation, is coordinating different types of insurance and making sure that each of those different types of insurance companies and coverages do what they're required to do under the law. And in situations like that, the hurt person ends up having to figure out what insurance is responsible for paying things like medical bills, lost wages, damages, and that often requires dealing with a host of different kinds of insurance, including health insurance, including things like Medicaid and Medicare, third-party liability insurance, first-party medical payment and UIM type coverages, workers' compensation insurance, disability insurance, sometimes event coverages like AFLAC and things like that. And dealing with all of those different kinds of insurance can be a pretty daunting process, even if you just have orthopedic injuries, even if you just have a back injury or a leg injury or something. Those insurers have powerful motivations to save themselves money. And they work or they communicate with both providers, but especially with patients and their insureds with complex gobbledygook fine print and letters that are intended to leave people thinking, I'm not quite sure what they meant. Do I have coverage for this or not? Are they going to pay this or not? And understanding who's supposed to pay for what under complicated esoteric insurance law is difficult enough for lawyers. We have a lot of lawyers that get hurt that come to us. They say, man, I'm a lawyer, but I don't have a clue how this world works. Will you just handle my injury case? Because it's a pretty specific kind of thing. So if you're unlucky enough to be in that situation with a head injury and you don't have people around you that can, like Pat, maybe like your wife did for you, but it's just impossible. Like if you're really struggling with cognitive effects and all the suite of things that we all know come with different kinds of head injuries, and you're also trying to deal with a powerful insurance company that's kind of doing this to you, and it's really an untenable situation. It's very difficult. But as the providers know, and I'll defer to the providers in the room, but it's also critical that, especially after an injury like that, the preeminent neuropsychs and other folks that I've worked with over the years say, man, you get a year or 18 months to heal from a head injury. And then, you can always, you can go to Emma and learn something about speech path, right? And work around things. But they say a lot of, you don't get a lot of organic brain healing after 18 months. So you can't afford to spend the first year post-accident stressed, underwater, not sleeping, trying to fight with insurance companies and also trying to heal your brain. Like that's not a way to heal from a brain injury. So that's what I'm going to talk about, is kind of how to make your way through that insurance system in the wake of a brain injury. And by brain injury, I mean everything from concussion that might cause you headaches for a couple weeks to a catastrophic TBI that could leave you with intellectual or motor function or other deficits permanently. I consider all that TBI. I want to talk a little bit about these different kinds of insurance I was just describing. So health insurance includes Medicaid, which is a state program which provides health insurance, and the providers in the room are like, yeah, we get this stuff. Medicare, which is a federal program that provides health insurance, and then the suite of other kinds of health insurers that are out there, whether they be health insurance that you get on like the ACA exchange and that you buy yourself, or like ERISA type health insurance policies that are provided through an employer. Those are different kinds. The law treats those kinds of insurance differently, but they're all health insurance, right? Third-party liability insurance is the most common example is auto insurance. So if I hit you in my truck, you can call State Farm, and they are, for you, they're a third-party auto insurer because you don't have a relationship with them. I do have a relationship with them. That means for me, they're my first-party automobile insurer. Third party is important because that in a liability situation, whether it's Home Depot's insurance or the insurance for the person that hit you in their car, what have you, that's one of the primary places that you can make claims. First party insurance is also important because there's different kinds of coverages that come with your own, in the context of auto insurance, that a lot of people don't realize, but can be critical sources of payment for things like, concussion treatment that come from your own insurance. So that's an important distinction. Also, workers' compensation coverage is sometimes involved, depending on whether you got hurt on the job or not. And you might have just been sitting in a car coming back and forth from Big Sky, but if you're on the job traveling, your work comp insurance might pay for medical bills. Disability coverage is sometimes implicated. And again, sometimes event coverage, like we don't deal with it a lot, but things like AFLAC, they have coverages sometimes where they say, if X, Y, or Z happens, we'll pay you $5,000. And it's pretty simple, straightforward kind of insurance coverage. So two of the primary issues that I see for people who are dealing with head injuries and are in that space where they have to try to heal are how to get your medical bills paid for, and if you're in a situation where you're working and you need compensation from your work, how to get lost wages paid for, because it's really hard to, again, heal from a head injury if you're sweating bullets about how you're going to pay your mortgage and all this kind of stuff, and you don't know how to get lost wages paid or something like that. So first, let's talk about medical bills in the wake of a brain injury. And I think I'll use auto collisions as an example. Probably we might be pretty representative here, probably 2 out of 3 head injuries that we see in Montana come from auto collisions. Then not far behind, horses, ski accidents, all the other things. Yeah, no, I haven't had a lot of tramp cases, but I wouldn't be a bit surprised to see that they're significant, and probably neck injuries too, right? Yeah. And like I said, just feel free to jump in anytime if you guys have questions, providers or not. With respect to medical bills, and medical bills are a little bit more complicated analysis than lost wages, but medical bills in Montana, in the wake of an accident, are governed by, it's a case called Ridley is the name of the case. And the principle that Ridley established, and I'm proud that over the years my law firms have fought really hard to preserve this law, to actually create this law and preserve it for people in Montana. The notion behind Ridley is that a responsible party has to advance pay your medical bills as they're incurred, right? So let's talk about a car accident situation. Somebody hits you in their truck and you have medical bills, whether it's for your knee or for your head. Let's say you have $50,000 in medical bills. In a lot of states, the insurance company for the person that hit you gets to just say, hey, we recognize, uncle, it was our guy that hit you. We recognize we're responsible for the collision, and we will pay your medical bills someday when we settle your whole claim, alongside your loss of established course of life and your pain and suffering and whatever other damages you have. When we settle your case, we pay you all that stuff. And I've seen lots of situations where that gets really abused, that kind of system, because they take, I've sat across the table many times with like single mothers who have a child with epilepsy and they work 2 jobs in Bozeman, and they just got a head injury, they can't think straight, and they've got some orthopedic injury too, and some insurance company comes along and says, hey, we're going to be there for you. We're your third-party insurance company. It was our guy that hit you. We're going to pay for your medical bills. If you want those paid, you're going to, we'll pay the 50 grand in medical bills, but you're going to take $5,000 for the rest of your claim if you want them paid now. Or you can wait 3 years and try to figure out how you're going to buy your daughter's epilepsy medication for the next 3 weeks. And what do you want to do? And just knuckle people in there, right? So one of the reasons I'm so proud of this law in Montana is you don't get to do that in Montana. In Montana, we get to go poke them in the chest, say, no. We'll talk later, someday, it might be 5 years from now, about what you're going to pay for their pain and suffering or their inability to walk for the rest of their life or whatever it is. But the medical bills you're paying today, so that you can't kind of do this to people. So that's real important. There's kind of 2 requirements under Ridley to get those things paid. And in the context of TBI, the type of medical bills I'm thinking of, and for the providers in the room, this is second nature, but it might be neurology consults, it might be neuropsych, it might be imaging like CT scans or fMRIs, functional MRIs, could be vestibular therapy or speech path or occupational therapy, counseling, and even closely related orthopedic injuries. Like if you've got a soft tissue injury in your neck and shoulders and it's causing you to have exacerbated headaches, and you're also dealing with a head injury, that can be a big piece of the puzzle to both be dealing with the complexities of a head injury and also, the exacerbations from orthopedic injuries too. So in situations where you're trying to get your medical bills paid for by a responsible company, in Montana, the law requires 2 things. It requires that it be clear liability, the collision, and it requires that the medical bill be caused by the accident, whether it's a collision or the bail at Home Depot or what have you. So clear liability means, and it's usually functionally just the insurer says, okay, we agree, our guy caused, it's somebody who runs a red light and hits you while you're just going through your green light, or somebody hits you from behind while you're stopped at a stoplight, right? Usually the insurers will say, okay, we're not going to fight that you caused this accident. We'll admit liability, or it's clear liability. That's the first criterion. The second is that any given medical bill that you're asking them to pay be caused by that accident, whatever it was. Again, whether it's the bail at Home Depot or an auto accident or something like that. And that's a stickier wicket because Pat was just explaining to me that he had a situation where obvious brain injury, and yet the insurance company came in and said, oh no, we think that this is a pre-existing condition, right? And that kind of stuff happens all of the time. I can't tell you how many times. It just depends. Like if you're in an auto accident and you're 20 years old and you've never seen a doctor and you have a broken arm, they're going to have a hard time saying, okay, that broken arm wasn't from this. But if you're 50 and you had a contusion on your right arm when you were 30 from a fall water skiing, and when you were 40, a horse bucked you off and you landed on your right side and you went to the ER once, and now you're 50 and you get in a car accident and your arm is broken and it hurts. I've seen them come back and say, well, we think that obviously the break, we'll pay for the break, but we think this long-term pain thing that you're experiencing or some loss of range of motion, we think that's probably pretty closely related to that horse accident. And we'll go pay some doctor, a flat fee of $4,000 to say, well, probably than not, that's contributing to this. So we don't want to pay for your medical bills after maybe just the acute injury or something. And that happens a lot. That can be really problematic. So while it may be, sometimes it's very complicated to prove liability and it's not accepted, but where it is, then the next kind of bugaboo is demonstrating that the injury is a result of whatever the accident was, whether it's a collision or some other kind of thing. One of the things that can help with that, and this is really important for providers, is to actually note that it's related, because that'll often shut an insurer up. That same kind of hypothetical I just gave. If the orthopedic person that's working on the arm says, look, this is obviously, I'm dealing with this broken ulna, and a loss of range of motion, and I attribute it all to the auto accident. A lot of times providers don't speak to that, and folks that work in the head injury world may be more conversant with this and have a little bit different perspective. But a lot of providers I see say, look, I'm here to fix people. I'm not here to like figure out why they got hurt. And so they'll often leave a common sense note like that out, just because they don't see it as their core job to be annotating for an insurer. They're trying to heal you, right? And but just a single note like that can make a radical difference, because I'll be on the phone with some adjuster saying, come on, man, the loss of range of motion in the arm is obviously related to the broken arm. And they'll say, well, I don't see any note from the doc. If we had a one sentence note in here that says all this seems to be related to the car accident or the bail at Home Depot or whatever it is, that makes a big difference. So if you're in the position of trying to get that kind of coverage, for that kind of payment for yourself or for a loved one, it helps to tell a doctor that, hey, can you just note what you think this is from? And if you're a provider, that can be powerful too, especially because in the head injury context, again, I think maybe y'all might be a little bit more versed in dealing with kind of subversive injuries that a lot of people don't see easily. You know, like it's easier to see an orthopedic injury in an x-ray than a brain injury. But it's also really easy to ascribe some symptoms of brain injury to other things, right? The insurance company says, well, yeah, you know, I say, obviously they're depressed. 6 months ago, they got a head injury that keeps them from working or thinking straight. They can't leave their room. They're spinning. They can't be in bright lights. They can't hear loud noises. They can't go to their kids' school programs. They can't go to school sports, whatever it is, and they're depressed. And some insurance adjuster will say, well, I think they're depressed because they had incest in their family when they were 30 years ago, or they're depressed. Honest to God, I've had that exact explanation. Or we think they're depressed because they weren't happy at work, a year ago, or whatever it is, right? And it's much easier to attribute many of the problems that accompany brain injuries to a host of other causes than some orthopedic injuries. So I guess that's just something to be cognizant of as a provider. Speaking of providers, the next part of what I'd like to talk about is probably compelling for providers, especially folks that work in billing or anywhere near it. But there's this complex interplay between what we've been talking about, which is liability insurance, and other types of insurance, like health insurance, for instance, right? We often tell our clients to go to try and ask their providers if their providers will bill their health insurance, right? And some providers say, no way, no how, we'll never take Medicaid or Medicare, and I understand why. Some providers say we will take private insurance. Some providers say, well, in the context of an injury, if this is a car accident, we're not billing health insurance, we're going to bill auto. We have a right to do that, we want to do that. That interplay is very complicated, and it can have really important ramifications for my clients, your patients, and people who have been hurt. I'll just give you an off-the-cuff example, but let's say you get hit by somebody who has Montana's minimum liability insurance for autos is $25,000. Half the people driving around Bozeman have $25,000 worth of insurance. And if they hit you, you can use $25,000 in the first 10 minutes, going to the ER and being in an ICU for 3 days, boom, you got $30,000 in bills. Let's say the person that hit you has $50,000 in insurance, and you, whatever your injuries, you go into the doctor and the doctor says, okay, we're going to bill your health insurance. And they bill the health insurance, and you have Blue Cross that you got on the exchange, and Blue Cross for that $50,000 in medical bills will satisfy it for $30,000, right? That's their preferred provider rate. They only pay $30,000. That's how they get you to sign up with Blue Cross. They say, hey, we have the biggest network and the best preferred provider rates, right? So come with our insurance. And that can be a real advantage in some contexts, because you have that $50,000 in medical bills, and your provider bills them to Blue Cross. The provider gets paid the preferred provider rate, $30,000. And sometimes when you wake up from a coma, you don't even know this is going on. You wake up from a coma and you say, whoa, okay, at least the guy that hit me had insurance. I need to go see what I'm going to have to build a ramp on my house because I got a broken back now. I'm not going to walk again. I got to go see what that insurance coverage was. And you pivot, and the insurance company says, we have $50,000 in insurance. And even if they reimburse Blue Cross Blue Shield, there's $20,000 left for you to build a ramp on your house or pay for your lost wages or what have you. Whereas if you walked into that provider and they said, no, sorry, we don't want to bill health insurance. We want to bill the auto for this, right? And they bill the $50,000 in medical bills to the auto insurance. Then you wake up from your coma and you say, thank God, at least the guy that hit me had insurance. You pivot to his insurance company. You say, I need that $50,000 to build a ramp on my house. And they turn their palms up and they say, sorry, that money's gone. We paid that to the doctors because we paid them 100% instead of the preferred provider rate, right? And I know this is a complicated and emotion-filled area for both patients and providers. I'll talk a little bit more about this in a bit. The landscape is shifting on this, but it's a very important issue. And our advice to our clients is usually, if you can have the health insurance pay for your medical bills, if the providers are willing to do that, do it that way, because then you get the benefit of your preferred provider rates, right? I'll just mention this briefly.
Just on that point, so
yeah.
the insurance will pay that, so even though you bill Blue Cross,
Mm-hmm.
Blue Cross then does go to the auto insurance and tries to get someone to pay that?
Yeah, let me just, I'll just kind of talk about it a little bit because it really is a kind of a sticky set of circumstances, and it also involves subrogation, and it also involves complicated things happening in our legislature in the last 2 sessions. I'll just tell you, our supermajority legislature for the last 3 sessions, longer than that, but at least the last 3 sessions, has done everything they can to pander to the insurance industry in Montana. Most people don't see it. I follow it because my professional organizations follow it. We lobby and we go testify and all this kind of stuff. But our supermajority in Montana has just tried. The Chamber of Commerce comes to them, driven by the insurance companies, and says, hey, you should pass this law that makes it easier for health insurers or liability insurers to make more money and not have to pay claims. And they do it like that, right? And they have passed a couple laws in recent times that really complicate this landscape. One of them says that medical providers are entitled to bill 100% of their medical bill to liability insurance, like auto insurance, and they don't have to accept a provider rate when they do that. Alternatively, they have passed another law last session that says liability insurers don't have to, at least in the context of like a trial where you go and prove your damages, they only have to pay what health insurance would have paid. So they've set up this weird dichotomy in the law where there's a constitutional issue where one law says you can get providers get 100% from liability insurance, but liability insurance doesn't have to pay 100%, right? That is going to be an issue soon. This has just come up. This particular sticky wicket has only come up in the last couple of years as these laws changed. And I'm happy to talk in more depth about what all this stuff means. The truth is that the people in my line of work are still on a daily basis trying to figure out how to reconcile those things and how to make sense of the law. And the Supreme Court of Montana is going to have to resolve some of that stuff. A closely related issue, and Kathy, I think core to what you're talking about, is an issue called subrogation. So let's say that that you hit me in your vehicle, I'm hurt, and my insurance I got from Blue Cross Blue Shield on the ACA exchange, right? If I go get medical treatment and it's billed to my health insurance, I go get, I don't know if the numbers are important, but I go get $30,000 in medical care and Blue Cross pays that. If I subsequently go, the guy that hit me had $50,000 of insurance, or you had $50,000 of insurance, and I might have, $300,000 in damages. Maybe I have a broken back and I'll never walk again, whatever it is. If I recover that $50,000 in insurance, in some circumstances, Blue Cross will come to me and say, hey, we already paid your medical bills. Part of what you just got reimbursed for was medical bills. Even though your damages were far in excess of your medical expenses, we want to be paid back. It's not fair that you get $30,000 from the insurance policy for medical bills that we paid, right? We should get that money back. That's called subrogation. If this is another kind of wonky area of the law, but if I got that policy on the ACA exchange, that Blue Cross policy, and Blue Cross doesn't have a right to subrogate. They can't come take that money out of the 50 grand that's available to me from the auto insurance. However, if I got that Blue Cross coverage through my employer and it's subject to a law called ERISA, the Employee Retirement Income and Security Act, that law at the federal level gives insurers powerful rights of subrogation. And that's the only distinction. If I bought it on the ACA, Blue Cross doesn't get that money back. If it was provided to me by my law firm, then when I recover the $50,000, Blue Cross comes knocking and they say, we want our 30 grand back, and they get it. They get it. That's also how Medicaid and Medicare work. They have powerful rights of subrogation. Just the same as if it were subject to ERISA. It's different because it's federal legislation, but Medicare, in my experience, is less willing to deal than Medicaid, the state programs. But in either event, if my health insurance, it's Medicaid or Medicare, pays for medical treatment, and then I recover money from a liability policy, they have powerful rights to get repaid whatever they paid. And sometimes that eats up the entirety of you can have $100,000 in medical bills like that, and you can have $100,000 in coverage, and when you get that money, it goes straight back to Blue Cross because they already paid those bills. Yeah.
So once like the person, say she has $50,000 of coverage and you get that, but you still have more bills.
Yep.
Is that when you are suing the third party insurance, or what happens?
Well, it's complicated. So let's say somebody hits me and they have $50,000 in insurance, right? And they don't have, very rarely do I pursue an individual like for their assets or something. Let's say they're just a normal person. They own a car and they own half of a house in Bozeman and they're working their ass off, and they're not affluent, and they're just normal folks who made a mistake. That person that hit me or hit my client, if I want to recover that $50,000 from my client and they don't just pay it, then I have to sue the person that hit them, right? And so what happens is we file a lawsuit against the person that caused the collision, and then that's a thin proxy because their insurance company steps in and says, okay, you're really suing us, right? And we look at the insurance company and we say, okay, pay the $50,000 and we'll let this person out of this. We're not going to try to take their little car or whatever it is. We're not going to try to grind them for another $5,000 and ruin their life. We just want the insurance policy proceeds. So that's usually how it works. You file a case against the person who caused it, but the real paying entity is the insurer. And usually you don't go beyond. I don't usually go beyond that. It just depends. I have a case right now I won't even name the exact facts, but the guy that caused the collision is enormously affluent. I don't have any problem saying to him, hey, I don't care whether he has to pay $100,000 or $1 million out of his own pocket, and frankly, he doesn't care either. So in that circumstance, it's good for my client because he had a couple $1 million in insurance, and he's also got plenty of assets to satisfy a judgment or pay a settlement in excess of that. But rarely is that the situation, and most of the time, it's not useful or productive to go trying to take somebody's half paid for Subaru or something. Does that get at what you were asking?
Yeah.
Okay. Yeah.
Question. So if the patient is using their medical insurance to pay for their care, they still need to pay like their co-pays and their percentage and their deductible.
Great point.
I mean, right?
Yep.
The difference would be with auto insurance, it would be covered 100%, the patient would have to pay for anything. Is that?
Yeah, that works a couple different ways. So again, for a hypothetical, let's say somebody hits my client and that person has they have a bronze plan that they have a $6,000 deductible and then everything up to $2 million is paid for, right? That if they go to their Pacific Source Health Insurance and say, hey, I have $10,000 in medical bills, will you please pay my medical bills? Pacific Source says, sure, we'll process those bills for you. We'll send you the EOBs. The first $6,000 will show what you would owe for it, but you owe 100% because that's all within your deductible, right? So, and then we will satisfy the other $4,000 in bills. And sometimes they just pay, in that kind of plan, they pay 100% of the $4,000, and it's relatively simple and discreet. Then you can pivot to the auto insurer and say, well, there were 10 grand in bills. but $6,000 of it they had to pay themselves. The health insurance couldn't pay it. So why don't you pay them back their deductible at least, so they're not out of pocket their deductible, and then the other $4,000 will be covered by auto, for instance. It becomes slightly more complicated when you have co-pays because they're like baby deductibles, right? And you might have a $6,000 deductible, and then for the other $4,000, that was 7 different visits. For each visit, they have a $50 deductible, and pretty soon you're in a spreadsheet that is just a downward spiral trying to track, and that's what we do. Yeah. We have paralegals that are darn near accountants because they have to keep track of 17 different insurance policies and 12 different providers and 10 different years, and it becomes very complicated. So in terms of those subrogation issues, I've talked about the fact that policies you get on your own rarely have a right to subrogate. Policies that are subject to ERISA, which is usually policies through your employer, they do have a right to subrogate. Medicare and Medicaid have rights to subrogation. Workers' compensation has a right to subrogation. So if you have a client that was driving back from Big Sky from a job, he was in a concrete, or he was in a, he installed granite countertops, and he's in a 1-ton truck that has, that's the granite countertop installation truck, and he's in the passenger seat. There's somebody else in the driver's seat. They're driving back from Big Sky, and there's some kid in a sedan behind them. It's slushy roads, passing people on the double yellow line going like 80 miles an hour, coming back from, it wasn't even skiing, it was in the fall, but and passes the car behind him, and pulls out and passes my guy in the granite countertop truck, and there's a landscaping truck, another 1-ton pickup coming the opposite direction, going towards Big Sky, and ducks back into the line of traffic really fast enough that he kind of fishtails. And this part of his fishtail hit the back end of that 1-ton truck coming the opposite direction and just knocked it kittywampus just enough that 2 1-ton trucks just going 70 miles an hour, head-on collision. It took him like 3 hours to cut this guy out with the jaws of life. Those kinds of situations, just give rise to enormous medical bills and these subrogation issues and just a world of complexity for who has to pay for what. In that situation, he's covered by work comp. So work comp pays for his medical bills, but then if I go sue the guy who caused, in that case, he had $100,000 of insurance, which is kind of a lot, but the kid that caused this collision, and work comp is paid, $300,000 in rebuilding this guy's pelvis. And if I go get the $100,000 from the kid in the sedan, work comp just says, okay, turn it over, give it to us. We paid more than that, and we're taking it. And he's out of luck, right? Except for other kinds of coverage, which I'll talk about. But then you pivot to things like first-party coverage, which you know something about, Pat. And that is a circumstance. In his case, there was coverage on his vehicle, which is, again, first party, and they had $1 million in coverage for what's called UIM, underinsured motorist coverage. So, and I'll just tell you right now, I tell all my clients this, if you're looking at your own auto coverages, if you want to max one of them out, max out your UM and your UIM, because UIM steps in when somebody hits you and they don't have enough insurance to cover your bills. And if you get seriously injured by somebody with 25 or 50 grand of insurance, not a chance that's going to cover it, right? You can have $500,000 in medical bills in a month. And if the person that hit you had 25 grand, you're going to end up owing $475,000 on your own, right? So that's when UIM steps in, underinsured medical coverage. And it says the person that hit you didn't have enough. They were underinsured. So now we kind of step into their shoes. And if you have $1 million in coverage, they say, we'll pay up to $1 million of whatever else your damages are, whether it's medical bills or loss of established course of life or what have you. So that's very important. Closely related is UM, which is uninsured motorist coverage. So if you get hit by somebody who just doesn't have insurance at all, then your coverage steps in, and you want it to be $500,000 if you can, because you could be hurt badly. And then they step into the shoes of that person that hit you without insurance, and they say, okay, we'll pay you $100 million, we'll pay you, $500,000 if you're, or whatever your damages amount to. So those are important. Strangely, those are also pretty inexpensive coverages. So maximize those on your own auto coverage. Yes.
I think I heard you there. You were saying about they can come back and ask for payment.
Yes.
Is that what's going on in Medicaid puts a lien on your
Yep.
house?
That's exactly what's going on.
Because when I sustained some injuries, one of the first things I was advised to do was go on Medicaid and thankfully I didn't. I am a homeowner.
Yeah.
And I'm now working with an attorney who's helping me create a ramp into my future medical life.
Yeah.
And the first thing we, decided was I absolutely shouldn't go on Medicaid until the house I have right now is sold.
Interesting.
And it's like outside the 5-year look back and all that.
Yeah.
Questions for us.
Yeah, absolutely. So the question is about subrogation and about the rights of insurers that have a right to subrogation, whether they can lien different things. And it's quite rare. I don't know, in the years I've been doing this, I don't think I've ever seen Medicaid lien someone's home. They will often send us a lien that says, hey, we paid medical bills on behalf of this person, and if you recover any insurance proceeds, you're not to turn a penny over to the hurt person until you talk to us first, because we have a lien. I've never seen them say, we're putting a lien against this person's house. That's really aggressive. What's that?
It happens more often toward end of life.
Yeah, yeah. Well, that's
I co-own a house.
Yeah.
So we're trying to put in projections for the co-owner.
Yep. So Medicaid has a pretty powerful right to be reimbursed. It's statutory in Montana because it's a state program, but it's similar to what Medicare has federally. And what I see with both Medicaid and Medicare, it's commonly, let's say you're hurt, you get $100,000 in medical bills, including treatment for a head injury. And Medicare pays, or Medicaid pays that $100,000 in bills. They'll send me a lien that says, don't you dare turn over insurance money to this person until we get paid first. And if I go settle that, the person that, say it's a car accident, the person that hit them had $100,000 in insurance, I'll get that $100,000 check, I'll pivot to Medicaid and say, okay, come on, you guys, like, this isn't really that fair. This person has $100,000 in medical bills. They lost 3 years of their life. They have, a permanent deficit in, some brain function. It undoubtedly impacts them in myriad ways for the rest of their life. $100,000 is all that's available, and you're going to take all of it. And they have to pay a third of it to me for recovering it for them. Sometimes that's the circumstance. And we'll go to Medicaid and say, hey, how about we cut a deal where we know you're due $100,000, but you wouldn't get a penny without us. Why don't you cut it into thirds? Let the lawyers get paid for doing their work and recovering this money. Let the hurt person get a third of it, and you take a third of what you're owed. And Medicaid is pretty good about that in Montana. Medicare is much less. Sometimes Medicare will deal with us, but a lot of times Medicare just says, no, sorry, we're just doing the math, and these are our rights, and take a hike, pay us the money. Federal program. Just depends. But yeah, good question. That's how those liens work. Yeah.
With UIM, if you're hit and the person that hit you, they have insurance, but their insurance isn't paying you nothing.
Yeah.
And you go to your auto insurance and say, hey, I have UIM coverage.
Mm-hmm.
And they say to you, well, you do, but they're not actually underinsured.
Yeah.
They're just not paying
Mm-hmm.
bills.
Yeah.
So we're not going to pay anything. Is that correct on their behalf, or is this another sticky wicket?
Oh, it's definitely a sticky wicket. I just had a case exactly like this. Sometimes you can go to UIM, and let's say the person that hit you had $25,000 of insurance, right? And they're refusing to pay that 25, but it's obvious who caused the collision. And let's say you have $100,000 in medical bills already, and obvious long-term impacts from this. So your damages are, $200,000 or $300,000. I have sometimes gone to UIM insurers and say, look, we're having a little fight with the primarily responsible insurance policy, but it's only 25 grand anyway. This person's got 100 grand in medical bills. You have to step in right now. And if a UIM insurer under those circumstances didn't do what they were supposed to, I'd sue them. And you have much more powerful rights against your own insurance company than you do against a third-party insurance company, meaning the one in this circumstance that's not paying. Under Montana law, your own insurance companies have complicated fiduciary obligations to you, just like your CPA does, that if they violate those obligations, you can sue them right away and force them to do it. In other circumstances, like I just resolved a case for a woman that the primarily responsible auto insurer disputed liability. It didn't dispute liability, it disputed how much the damages were. And we said, this person's damages are in excess of $300,000. So UIM, you have to pay your $50,000, and primary liability insurance, you have to pay your $300,000. They said, no, we're going to dispute this. And so we filed a case against both companies. And ultimately, they both ended up paying a portion of it. But they have to adjust your claim, but a UIM carrier can say, look, we respectfully disagree that your damages rise. In that example, if you have $50,000 of UIM coverage and the underlying coverage for the person that hit you is $300,000, you have to demonstrate to your UIM carrier that the damages are at least $350,000, right? So that they would be obliged to pay you that full $50,000 because you would recover the $300,000 from the underlying insurance, and then your own coverage steps in and pays you the other $50,000. In that circumstance, I went to the UIM carrier and I said, you're going to owe this anyway, just pay us the $50,000 right now. And they said, no, we don't think we're going to owe that. We don't think her damages are ever going to get to $300,000, much less $350,000. And that's why we ended up in a piece of litigation about it, because they're supposed to, what they said in that circumstance was, they said, we won't even adjust the claim because the conditions precedent to force us to have to adjust the claim haven't happened, so we don't have any obligation. And I took them to task for that. I said, no, you have an obligation to adjust the claim. You can tell me, and this seems like a distinction without a difference, but I said, you can tell me you're going to offer zero, but you can't tell me you're not going to adjust the claim. And we sued them over that, and ultimately they came out fine and the case got resolved. But so there's different ways that works, but if you are sure that your damages are going to exceed both of those coverages together, then you have a right to make a claim against your own UIM or UIM in this case, and say, hey, you need to pay this now. That's pretty aggressive, you know. It oftentimes takes a law firm to do that. Otherwise, they're just going to give you the runaround. Does that get at what you were? Okay. I'll jabber at you for just another couple minutes about lost wages, and then I don't have too much more. If anybody has questions, we can chat about them. But there's an analog of the Ridley case that's called Dubray, and that's the case that says just like you have to advance pay lost wages, you have to advance pay medical bills. You also have to advance pay lost wages under the same circumstances. It's a clear liability collision or accident. Somebody's clearly responsible for it, and the lost wages are a result of the injury from that accident. So it's often, you know, if you're a heavy machine operator and you get in a collision and you break your back, it's pretty easy to go to the insurance company for the person that hit you and say, look, he's got a broken back, he can't run a backhoe for the next year, and he needs his lost wages paid, and you don't get to tell him, oh, maybe we'll pay your lost wages in 6 months if you take a third of what your claim is worth, right? You don't get to do that in Montana. You have to pay them as they're incurred, or you have to advance pay them. That's how the insurers like to talk about it. That's a straightforward enough situation. Much more complicated if you have I don't even know what a good example is, but some job where it's not as clear that the injuries from the collision absolutely prevent you from doing your job. Then sometimes you end up in a spat with the insurers over, you're saying, okay, is it an admitted liability collision? Yes, it is, but we don't believe that the inability to work was caused by the collision. We think that was caused by some other accident they had 2 years ago, or some other thing that's manifesting now, their depression, that isn't a result of this collision. It's the result of, you know, their son was killed in Iraq, or, you know, all kinds of things like that kind of figure into that. Again, just like kind of the cautionary note for providers, especially about how you record things in medical records. If you were the hurt person, or you're taking care of a loved one who's a hurt person, and you want to avail yourself of getting those lost wage payments, it really helps if your provider, if they write an off work note, or if they just note in their medical records, the off work note says, Jenny was in this collision, or Jenny's having these problems, I don't want to see her working for the next 2 weeks. If they just put in a sentence that says this is because of the collision, that really helps, because then it's hard for the insurers to wiggle. Same thing with just a medical record. And it's trickier too if you're a counselor and you say, well, Jenny comes in today and she's depressed and struggling with lots of things, and I don't think she should be working right now. In the medical record itself, it's much easier for me or for her to get her lost wages paid if you say it's because she's depressed about the fallout from this collision. That's what it takes for me to get on the phone with an adjuster and say, come on, you guys, you got to pay these lost wages, so that this person's not in enormous financial distress at the same time they're trying to heal from a brain injury and, you know, trying to figure out how they're going to live their lives and all the complicated things. So that's the rule about lost wages, and that is a case from Montana called Debray. There's other kinds of coverage that I'm not really talking much about today, but some things that you should have in mind if you're thinking about these issues. One is disability coverage. Yeah.
I have a question about the wages.
Sure.
Like when I think about work comp, if your doctor says like, okay, you can't do the job that you're doing.
Yep.
Injury, but you could potentially do a different job.
Yep.
How does that work?
Great question. The answers are different depending on whether you're talking about the work comp system or some other system. You have an obligation under Montana law to mitigate your damages. And oftentimes we'll have, you have somebody who was a orthopedic surgeon who got their back broken and they can't do surgeries anymore. You say, hey, this person made, $300,000 a year. They can't work anymore. You have $1 million insurance policy, pay it. And we'll have insurers come back and say, well, they can do something. They can be a greeter at Walmart. And that's $25,000 a year. So we're subtracting $25,000 every year for whatever it is we owe you. And you're just like, okay. That's how that obligation to mitigate your damages and do some work, if you can, works with with a liability insurer. Most of the time, that doesn't happen in the weeks or months following a collision. If you have a doc that says, hey, I'm writing so-and-so comes in today, they were in a catastrophic auto collision, they have a broken femur and a head injury, and I'm taking them off work. And it's 3 months of off work time, right? And they did a hard manual labor job where they needed their femur and their head both, right? It's usually pretty, in those circumstances, rarely does an insurance company come in and say, well, we don't want to pay the whole lost wages. We can usually, cow them under and make them pay those lost wages. It happens more often where we have somebody that's got a mid-level injury, there's $1 million insurance policy, and we go to them and we say, look, this person's going to deal with this for the next 30 years of their life. We think you owe them this $1 million. And they're adding up different buckets of types of damages, and they're saying, well, the pain and suffering is worth $130,000, and the emotional distress is worth $80,000, and the loss of established course of life is worth $100,000, and the lost wages are worth $200,000, but we want to reduce those because even though we recognize, like sometimes we'll go out and get a neuropsych to say, look, this person can't do their job. And I don't use neuropsychs a lot, but sometimes I've run into a couple of them that were quite capable doctors. And sometimes those are the situations where they say, well, this person can't do their job, and the insurance company is kind of disputing those damages, and they'll say, well, you have to mitigate your damages. Even if they can't work as an orthopedic surgeon, they could work as a used car salesman and make $60,000 a year, so we're subtracting that out. So that's kind of how that shakes out sometimes. So the other stuff that I'm not talking about today is stuff like disability coverage. Some people have policies through their office or something where if you get badly injured, it'll step in and pay lost wages and disability payments. That is an important thing to think about sometimes. We had a question before we got together today about the ADA, the Americans with Disability Act. That is not really a source of compensation, but it can be an important place to look, especially if you're a practitioner talking with people about what their options might be or something. It's not really your job as a speech path person to be like, hey, help me with your insurance questions. But sometimes it happens that way, especially if somebody's in and like, hey, I can't come see you anymore if I can't figure out how to get this paid for or something. The Americans with Disability Act often provides routes for people to get accommodations at work so that they can continue to do their jobs. Maybe they need all the things that you all deal with. Maybe they need blue blocker glasses and they need the lights turned off and they need a quiet place to work or whatever it is. But that's one thing to look at. Similarly, SSDI, Social Security Disability, can sometimes for catastrophic accidents and injuries step in and be an important source of support for people that need that. So those are things that you can have in the back of your mind as you're helping people navigate their way through something like this and trying to heal from it. We really did just kind of skip across the surface of some of the complexities of like subrogation and coordination of multiple insurance policies and things like that. But maybe at least you have a kind of a good working vocabulary of what those things are and kind of an idea about how they might fit together. And I'm always happy if people have situations where they're like, hey, how do we deal with this, to talk with people and, help figure people's way out through this process. Yeah.
Kind of to piggyback off of that, what are some things you would like to providers say you might want to refer to a law firm if people are saying this, like maybe when do you look for is that appropriate?
Yeah, absolutely. Great question. If it's a really significant injury, and if it's a really significant injury, people aren't going to get a fair shake without a law firm. It's if you get hit and you have $2,000 in medical bills, you go to the ER and then you go to PT 2 or 3 times, and then you're like, well, okay, I guess I'm healed up from this. And it's 5 months later. I have people call me all the time and says, hey, I've got $2,000 or $5,000 in medical bills. Will you represent me against, the guy that hit me? They have a $25,000 insurance policy. I'll usually just tell them, hey, you don't need me to take a third of your recovery on that. It's small enough that you can probably get them to treat you mostly fairly. And if they cheat you, it's going to be less than the third that I charge to go get you that money. If you have $100,000 in medical bills and a significant injury that's going to last for a long time, some insurance company or 2 or 3 of them are going to try to hose you. It's just how it happens. I mean, I've seen it I've seen it in my own stuff. I got hurt a little while back. Well, not hurt, but I got hit in somebody went across 4 lanes of traffic and head on me coming back from Big Sky. I was all the way over, like trying to get off the road. It caused like 25 grand worth of damage to the front of my truck. And my own insurance company, State Farm, tried to hose me. And I ended up in a first party lawsuit with them, suing my own insurance company. I was like, and that was like the 3rd one in my own circumstance. I was like, you guys, this is what I do all day, every day. Why do you not, just like, so silly. But if you're.
The third one is your third
Accident or?
Oh, no, first accident for me. Yeah, it was somebody else hit me. But, it was a 3rd insurance company in that circumstance that tried to not do what they were supposed to. And that's a simple property damage claim, right? If you.
The driver's insurance company.
Yeah.
Hit you. Is the third party.
Yeah.
Yeah.
And then my own insurance for UIM for damage to a vehicle. But long story short, if you have a really serious injury and you have to deal with, say, another person's insurance company for their car, and then your own insurance company for your car, and then maybe something like work comp or any number of these other kinds of coverage, invariably they have it's the really astute insurance adjusters that do it, and they never do it in writing. I tell all my clients or people that I tell you don't need a lawyer, just do everything on email, do everything in writing, because if they're going to try to hose you, they will do it on the phone, and they do all the time. But they don't record half the conversations they say they record. And if they're going to lie and cheat, it's better to make them do it in email, because then you can bring it to a guy like me and we're like, I can't believe they're doing this to you. They wrote it down, But it's really common. It's just like those industries have powerful profit motives, and they're very astute, and they have just titrated their systems, like just, thousands of accidents a day all across the country. A company like State Farm or Farmers or whatever, Geico, these big insurers, they have just created these little rat mazes for their adjusters and sets of rules about how things have to be done. And they have done it in a way that just cuts every edge for profit for them. And then the really astute adjusters are kind of like, well, I could just kind of say some things to this person that maybe confuse them a little bit, especially if they have a head injury. And they'll probably just eventually get tired and stop calling me about
Or
this.
threaten them.
Yeah, sometimes. Really?
In a mediation.
Oh.
I said, you gotta be kidding me.
That's a weird circumstance for that, but yeah.
It was really interesting. I said, I think we're done.
Yeah, crazy. Yeah, it's what happens when you give people the ability to make big profits at the other people's expense. It's just like, honestly, I'm so cynical about it after years of doing this, but I'll just share one more anecdote about that. I once saw a memo from a major insurer that prioritized, I just feel dirty even saying it, prioritized hiring single mothers to be adjusters, because single mothers needed their jobs to feed their kids, and they could get single moms to do things to people that no other adjuster would do. And they actually had a white paper by quite an astute, like one of the world's great auditing companies that came in and said, how can we up your profits? And they said, well, here's one place, hire single mothers to be your adjusters. And they wrote it down in a white paper. And then they create incentive programs that they try like hell to keep you from learning about, but they create incentive programs where they have like a profit share, as it were, with the adjusters. And they say, well, if you're told, and it's all in this double speak, but if your total loss ratio is this percentage below what we anticipate, then you'll get this kind of bonus. If you can get it a larger, incremental percentage down, you get a bigger bonus. And we always ask about those things and say, oh no, there's no such thing. There's no such thing. And then we, 1 out of 10 times we actually get the true answer in, some deposition, and some person is like, yeah, I got a big bonus for that because I was 20% under what I was supposed to pay, yeah, it leads to cynicism, but anything else? Go home on a rainy night?
At the beginning of your talk, you said you represent hundreds of clients in car accidents. I don't know if there's head injuries or not, but each year. Of the calls that come into your office saying, I'd like representation, about what percentage would you say you're turning away? So like, is it 1,000 a call and you take 100?
Yeah. We probably at any given time, I don't know, we have 100 car accidents in our office at any given time, but we do a lot of represent people that are in auto collisions, right? And that, like I said earlier, that's how a lot of our other litigation arises. We see somebody getting cheated, and if it's a systematic process, we say, hey, that's a class action issue, and we go after the insurer in a class case. Sometimes I'll take a case just because I see a significant issue like that, even if it might only be hurting this person to the tune of, $500. If they're doing that to 50,000 people in the state of Montana, those people deserve to have their $500 back, right? And sometimes we'll file that as a class action. Like I said, it's often the case if somebody comes in with really minor damages, and even if the insurance company cheats them, they're going to get $1,800 instead of $2,000. It doesn't make any sense for them to hire me and pay me a third of their $2,000, and suddenly they're getting $1,400 instead of $1,800, even if they get cheated, right? And I'm just candid with people about that. On the other hand, if it's a real significant issue and they're going to get burned for some reason, sometimes I'll take those small cases too, just to make sure that they get, even though it's not profitable for us. On the other hand, a case where you have significant injuries, like we were talking about, if you have $100,000 in medical bills, my experience is you're not going to get treated fairly if you don't have a law firm, because you have to file a lawsuit. And even if a law firm charges a third of what they recover for you, like I don't usually take a fee on medical bills that I recover the first time for somebody, something like that, because then they don't have the money to pay for their medical bills, right? I can't, if you have $1,000 in medical bills and I go collect $1,000 and I give you 666 of it, you're now $333 short for paying your doctor, right? So I usually, it's complicated, it depends on circumstances, but oftentimes I'll just say, hey, I'm just giving you this money. But almost without fail, if you have a significant injury, you're going to need a law firm to process it for you, just because, and you'll come out far ahead. You make a lot more money even paying a third of it to a law firm than you would in a significant injury without somebody who knows the system and can deal with it for you. So.
It sounds like you do consultation, let them know,
Oh, yeah.
with that, so
I spend a lot of time.
free consultation.
Yeah.
Free, yeah.
Yeah, we have probably, I guess back to your question, for auto collisions, probably 7 out of 10 of the times that we talk to folks, we say, hey, look, let us just give you some good advice. If you have questions, you can call us back later, but right now you don't need to pay your money to us right now to pursue this. But if it's that person who's, got $1 million claim and you just have to file the case. I guess that's another important thing. That's not what I'm here to talk about, but in Montana, with liability situations, negligence and auto collisions are the most common example. You have 3 years to file a lawsuit against the person that caused the collision, or you're just SOL. Literally, it's a statute of limitations, and you're also out of luck, because if you don't file that case within 3 years, you lose all right to do that. And insurers watch that, and your accident was a long time ago, but if you waited till 2023 and you said, man, this insurance company is just working me over. I guess I'm gonna have to file a lawsuit. Too late, you missed it. If it was a 2019 accident and you're 3 years past that, you've lost all right. And the insurance company knows it, and they're like, sorry, we're not paying you anything. Don't care what the merits are, you missed it. And sometimes when it's 2 years in, if you don't have a law firm that can file the case and prove to them that you're gonna hang in there and they're gonna be on the hook, they'll just continue to wait and try to wait it out 3 years until you've missed the statute of limitations. And then they say, well, sorry, it's over. You don't have any rights anymore. So those are situations where you have to get involved. Yeah.
How long does it take on average to settle a car accident?
Yeah, good question. It really depends. It just depends so much. If it's some insurance company saying, oh, we're sorry, we don't think, it's $100,000 in coverage, but we don't think you're that badly hurt, and we'll pay you $20,000 and that's it. Oftentimes somebody will walk in my door and say, okay, we'll take your case. We file the lawsuit. The next day they say, okay, we'll pay you the $100,000. We're just waiting to see. Sometimes it's somebody with a claim where the insurance company is saying, well, we think you're only hurt to the tune of $200,000 or $300,000. It's $1 million policy. And we file that case and they say, okay, we will see you at the ends of the earth. We're going to hire defense lawyers and we're going to take depositions and we're going to fight this, and we'll go through the entire litigation process for 12 or 14 months. And then in Gallatin, you have a gap of probably 8 months before you can get a trial date. So you're 2 years into it before you get to go to trial. And then you go to trial and you prove to 12 people, hey, look, this is what happened to me and how it affected my life. And you get a verdict, and it might be $1 million verdict, and then they can appeal that. So you could be in, if there's an irregularity at trial, you come back for a new trial, you could be 5 years into it and still trying to get, the money that the insurance company owed you. Again, you're not getting there without a lawyer in that circumstance. But just depends, different circumstances. Sometimes it's right away, sometimes it's 6 months, sometimes it's 6 years.
But there's a real backlog for the trial aspect.
It's a shame in Gallatin, the way it works here. Some courts, when you file a case, they give you a trial date 14 months out. So you have 12 months of discovery. At the end of 12 months, you try to settle it with the other side. And if they don't settle it, you go right to trial. Our judges here don't like to do that for a host of reasons. And so here you go through 12 months of discovery, you go to a mediation, the insurance company says, no, we don't want to, you say, we think it's $300,000. They say, we think it's $200,000. They don't want to pay. Say, judge, we couldn't settle it. You go back to the judge and says, okay, well, we'll set it for a 4-day trial. The first 4-day trial I have is 9 months from now. And then everybody just sits on their hands for the next 9 months, and nothing happens, and everybody forgets about the facts. And then 9 months later, you have to go try a case, It just depends. But it's a little bit tricky that way. And that's one of the things I really dislike, is having to explain to clients. They're like, wait, we've just gotten through 12 months of kind of heart-wrenching litigation and whatever else, and now you're telling me I got to just wait a year before we can have any recourse? That's hard. Yeah. Okay, thanks you guys. Yeah.